Of course, as I've earlier told you, we're going to talk about the alternative dispute resolution in this continent. In studio, I have James Magerere, who's the President, Mediation Training Institute of East Africa and Advocate of the Kenyan High Court. I also have May Virgie. She's a certified professional mediator from Uganda. I also have Mr. Charles Getanda, a trainer of mediators at Mediation Training Institute. Good evening, ladies and gentlemen, and welcome to the program.
Okay.
Now, let me begin with the president himself, that is James Magerere, and we all know that there's some sort of high demand for legal and dispute resolution services, not just in Kenya, but across the continent. And I understand that you have experience when it comes to matters mediation. First of all, can you perhaps tell our viewers what mediation is all about and perhaps how different is it from litigation as we know?
Well, thank you very much. Mediation is assisted negotiation. Parties are negotiating, they have reached a dead end. And therefore, a third party who is neutral comes in to help these parties open lines of communication so that they are assisted to come out with their own mutually acceptable solution.
Mm-hmm.
Yeah.
So when you talk about two parties, we know in the normal court system, they're represented by lawyers. So when it comes to mediation, who represents each party and how a judgment perhaps offered, if there's any kind of judgment that is?
Well, it's important also to realize that the litigation, when we deal with the litigation, we are talking about the rights.
Mm-hmm.
In mediation, we talk about interests. And therefore, in mediation, there are issues that usually occur in disputes. And there are three. We have substantive issues, those needs, what people want. We have emotional issues and pseudo-substantive issues, that's what people need. So courts deal with what people want.
Mm-hmm.
They don't deal with what people need.
Yes.
That's why they don't delve into the issue of emotions.
Yes,
therefore,
James,
there's a big difference.
Yes, James, let me bring Charles into this conversation. Charles, we've had the technical bit there from the president of Mediation Training Institute of East Africa. Can you perhaps break this down for our viewers? For example, what are some of the major traits of mediation? Because I understand there's no winner or loser, as we know court processes are. Apparently, this kind of in this kind of dispute resolution, both parties win.
There is a big difference between mediation and litigation. Mm-hmm. When parties have their case decided by the court, mm-hmm. one party comes out of court smiling, another one comes out of court crying. That means there is a winner and a loser.
Yes.
But in mediation, it is the parties who control the process. Mm-hmm. They are the ones who make a decision. They own the decision jointly, and they can implement it jointly. Uh-huh. No one goes home complaining about what they have agreed.
Charles, what if, sorry to interject, what if somebody has committed an injustice towards, let's say, me, and I've come in front of the mediators, and I want this individual to be punished? I mean, how can you, approach that kind of a situation?
Now, the role of a mediator mm-hmm. is not to make a decision. So the mediator does not punish any of the parties. Mm-hmm. Actually, what the great benefit that a party receives through the process of mediation, mm-hmm. I will consider to be an apology. Mm-hmm. An apology is more satisfying than any other award that can be given by the courts. So the mediator does not make a decision and is not there to condemn any of the parties.
Yes.
It is the parties who should appreciate in what situation they are and what solution they want to arrive at. Mm-hmm. Yes.
We're going to, of course, you're going to take us through some of the types of cases, perhaps, that normally comes before you. But let me bring May Virgin to this conversation. She's a Ugandan, I believe. May, welcome to the program. And I understand that Uganda is on a much more advanced stage compared to other East African countries. How has it been for you? What kind of an experience have you had in Uganda with regards to mediation?
Mediation in Uganda is part of the mandatory system of the judiciary, and it has been fruitful, but it has its challenges that sensitization to different sectors needs to be done a lot more, but it is fruitful and it reduces the caseload for the courts.
Mm-hmm. And May, understand that you don't have to be a lawyer for you to represent any party when it comes to mediation, right?
Absolutely. I am the only one non-lawyer accredited by the judiciary in Uganda. I have 42 years of business experience. So when you mediate, as Charles said, you listen to the parties, you look at what are their interests, and you just let the parties decide what is their fate.
Now, James May has pointed out an example of a business dispute there. Perhaps one will ask, if there's no one who's going to lose when it comes to mediation, then what kind of cases do you normally, shall I say, arbitrate, or what kind of cases do you solve?
Well, mediation resolves 80% of the disputes: commercial disputes, family disputes, community disputes, workplace disputes, all sorts of disputes. The issue is that the purpose of mediation, why people have it preferred, is because it resolves the disputes but maintains the relationship. Because usually, when people are in dispute, if the court makes a decision, it means one party wins, another one loses, and the relationship is polarized. But in mediation, we go straight, resolve the dispute. We separate the problem from the people. Therefore, we resolve the dispute and maintain a relationship. And that's why it can resolve 80% of the disputes. In fact, generally, all disputes are mediatable. Only that we prefer to say that some of the disputes, like, for example, those ones which are of criminal nature, sometimes they're excluded from the purview of mediation. But still, most countries still resolve even criminal matters through the process of mediation. And probably I'll talk more about it in what we call victim-offender mediation later on.
Now, Charles, perhaps can you tell us how people have received this kind of alternative dispute resolution through mediation, and what are lawyers saying about it? Because I understand it's not that expensive compared to the traditional court system that we're used to.
I would agree with my colleague that in Uganda, they have moved ahead of us. But I want to say that in Kenya, mediation is picking up very fast. The pace at which we are moving, actually, it is the fastest in Africa, as I would say, though we have not gone very far. Now, when we look at mediation in Kenya, the general awareness is at a lower level, but they have started to pick up. When we now have the judiciary referring cases to mediation. We have a system where the court screens cases and refers them to mediation, and an appointed or accredited mediator can resolve the dispute. The challenge we have had, most members of the public who have filed cases in court want to believe that if the case is referred to mediation, the mediator would have to make a decision, only to find that the mediator doesn't make a decision. So the perception about what mediation is a challenge that we are facing in Kenya today. And I would want to say that those who have gone through the process of mediation actually embrace it and they really accept it. They may not want to be in court.
Yes,
however,
Charles. Yes, Charles. We're going to talk about the challenges shortly, but let me get this from May. Understand, of course, Uganda is on the advanced stage, and mediation is some sort of a very popular means of resolving dispute there. Why is it so popular in Uganda, and why are people moving away from the traditional court system and resorting to mediation?
I think, as stated earlier, it's the parties make the decision. So whatever you want to resolve, the parties are in control. Whereas if you go to trial, it's the judge who will make the decision. Relationships in the mediation are restored. People think they have done the decision making, and that is their power. And also remember that when you feel that you resolved your own issue, you feel much, much happier, and you feel on a high, because in mediation, as stated earlier, there is no loser. Everybody wins and goes away feeling satisfied that they got heard and they got what they wanted.
And that is what I've found interesting there when it comes to mediation. Now, James, can you perhaps tell us, is mediation in any way anchored in law?
Well, in Kenya, Article 159 of the Constitution gives an obligation to the courts, tribunals, to first of all, there are three systems of resolving conflicts stated in there. litigation, alternative dispute resolution, and traditional dispute resolution systems. Article 48 of the Constitution talks about access to justice. And access to justice does not mean access to the courts of law only. Access to justice means finding a means of dispute resolution which is peaceful. And I don't think that peaceful way of resolving conflicts is always found in the courts. That's why it's found in alternative dispute resolution. And alternative dispute resolution includes mediation. Section Order 59 of the Constitution, of the Civil Procedure Rules, that's the laws that we use in practice in law, has also described what mediation is. They have set up mediation rules, the mediation manual, and how we can use mediation in what we call the Court Annex program. So mediation is already in our laws. The only thing is that we have not sensitized Kenyans to realize that there is a better way. There is a better way of resolving conflicts. In fact, the Bible says, my people perish because of lack of knowledge.
Yes.
I want to tell Kenyans that there is a better way of doing things, of resolving our conflicts and maintaining our relationship.
James, there's a very interesting question. If then mediation is anchored in law, then how will people who are not lawyers, be able to mediate in this kind of a dispute resolution?
In fact, mediators are not lawyers. And that's why we have a large number of mediators now in the country who are non-lawyers.
Do they undergo training?
Yes, they have to undergo very intensive training. In fact, it's a 50-hour program. People always say that you can just mediate even if you are not trained, and I think that's very wrong.
Yes.
I know you get 50% of the skills through the University of Life. That's your social and emotional intelligence. But unless you are trained, that's given behavioral technology, how to influence human behavior, and you have proper training, not just training, because you want to deal with people's lives. Unless you have proper training, then you cannot properly mediate. So these people who are known as professional mediators are people who have gone through proper training. They have been assessed and found fit to handle human disputes. We are not dealing with animals. We are dealing with human beings, and therefore you require that kind of training.
Interesting. You're going to tell us more about what ICMC is all about, but let me bring Charles into this conversation. And Charles, you've talked about challenges earlier, but I'd like you to pinpoint the challenges perhaps you've received while entrenching mediation into the normal, litigious system that we're used to.
Yes, we have a few challenges that we are facing as we embrace mediation. One of the challenges that we have, lawyers themselves who represent their clients in the court, fear that if the case goes through the process of mediation and it is resolved by the parties, they will not earn their fees. That's one of the problems that we are having. Secondly, lawyers themselves who are representing parties, most of them have not trained as mediators and they do not understand what mediation is. Thirdly, we have a problem, we have a challenge. Parties who have filed suits, when the case is referred to mediation, they ask, what is the incentive? I've filed my case in court, I expect a decision. Why am I being again referred to a mediator, and the mediator does not make a decision, I have to make a decision?
But Charles, I'm sure you'll agree with me that there's some sort of cases that mediation cannot resolve, right?
That is correct. I would agree with you, like cases which involve public interest.
Yes.
Cases where you are challenging a law passed by Parliament, those ones you cannot go for mediation. A court has to make a decision. And in any event, some public entities also fear going for mediation because they will be subjected to public scrutiny. Why and how the decision was arrived? Because the mediation process is confidential. You only know the results that the parties have agreed. How they agreed is not disclosed to anybody other than the parties themselves. So where a public body is involved, like a county government or the government of Kenya, the Kenyans will want to know how the decision was arrived. So cases involving such entities may be a challenge going through mediation.
So there are certain cases that mediators can tackle, not all of them. Let me bring May into this once again. And May, Charles has talked about some lawyers feeling that they might lose out when it comes to the fees. In Kenya, people charge a lot of money when it comes to court cases and representing, of course, their respective clients. Have you received the same challenges in Uganda?
Absolutely. What Charles said, I ditto it, because our first hurdle is to educate the lawyers and see that we are partners with them. We're not taking their jobs away. We're actually helping them resolve matters for their clients most cost effectively, quickly, and effectively. And I think that they need to realize that we're actually there to help them, help their clients, get a better outcome and a faster outcome, as opposed to seeing mediation as a threat. Industries need to be educated and realize that whatever disputes that they have commercially, they can resolve it at a much less cost, quicker response, and effective, and maintain relationships and have confidentiality as well.
I think you've pinpointed some of the advantages there very clearly. And as we actually, let me take a very short break. We'll return with this conversation, which is very interesting. And of course, James is going to tell us what the Institute of Chartered Mediators and Conciliators is all about, and perhaps what one needs to do in order to qualify as a mediator. Of course, you've been watching Bottomline Africa right on KTN News. We're going to take a very short break. We'll be right back. But first, here is Destination Africa.